Section D clarifies requirements regarding the interim alternative educational setting, IES. IDEA does not define an IES. However, OSEP's data documentation file for discipline data collected under IDEA Section 618 defines an IAES as an appropriate setting determined by the child's IEP team or a hearing officer in which the child is placed for no more than 45 school days. This setting enables the child to continue to receive educational services so as to enable them to participate in the general education curriculum, although in another setting, and to progress toward meeting the goals set out in the IEP. As appropriate, the setting includes a functional behavioral assessment or FBA and behavioral intervention services and modifications to address the behavior violation so that it does not recur. This section of the guidance Q&A clarifies the circumstances under which a student may be placed in an IES and who makes the decision. There are several circumstances under which a student may be placed in an IES. This section of the document also identifies factors that can be considered when determining an IES, including the specific programs and services available in the alternative setting, such as additional counseling services, behavioral and academic supports, and other services or programs that could address the behavior that led to the need for the placement in an IES. If the removal is a change in placement under 34 CFR section 300.536, the child's IEP team, which includes the parent, determines the IAES for the provision of special education and related services. When a removal is a change of placement, as defined in the regulations, services are provided in an IAES following the 10th day of the removal. This situation may occur after a child with a disability has been removed from their current placement for 10 school days in the same school year. During any subsequent days of removal, the public agency must provide services and may do so in an IAES. An IAES also may be considered when a change in placement that would exceed 10 consecutive school days is proposed and the behavior that gave rise to the violation of the school's code of conduct is determined not to be a manifestation of the child's disability under the regulations. In this situation, school personnel may apply the relevant disciplinary procedures to children with disabilities in the same manner and for the same duration as the procedures would be applied to children without disabilities. However, the child would continue to receive educational services in an IES during the portion of the removal that exceeded 10 school days. Under 34 CFR section 300.530, school personnel may consider removing a child with a disability from their current placement and placing them in an IES for not more than 45 school days, without regard to whether the behavior is determined to be a manifestation of the child's disability if the child, 1, carries a weapon to or possesses a weapon at school, on school premises, or to or at a school function under the jurisdiction of an SEA or a district. 2, knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substance while at school, on school premises, or at a school function. Or 3, has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function under the jurisdiction of an SEA or a district. The IES definitions and guidance document listed here provides additional information on the factors that could be considered when determining an IES placement. Section E gets into the special circumstances. First, within 10 school days of any decision to change the placement of a child with a disability because of a violation of a code of study conduct, the district, the parent, and relevant members of the child's IEP team must conduct the manifestation determination review. However, regardless of whether the violation was a manifestation of their disability, when the removal is for weapons, drugs, or serious bodily injury, as defined under 34 CFR section 300.530G, the child may remain in an IES as determined by the child's IEP team for not more than 45 school days. If removed due to special circumstances, the student must continue to receive educational services to allow them to continue to participate in the general ed curriculum, although in another setting, and to progress toward meeting the goals in the student's IEP, and must also receive, as appropriate, an FBA and behavior intervention services and modifications that are designed to address the behavior violation so that it does not occur again. Under IDEA, the procedural safeguards and right to FAPE for a child with a disability must be protected throughout any threat or risk assessment process, including the provision of services during any removals beyond 10 cumulative school days in a school year. Section F. This section clarifies the obligation of the ARC to hold a manifestation determination review each time that a student is removed for more than 10 consecutive school days, and each time that the district determines that a series of removals constitutes a change of placement. This section also explained the 5 W's regarding manifestations determination reviews. Those include 1, what a manifestation determination review is. 2, when must a manifestation determination review be conducted? 3, when a student's behavior must be determined to be a manifestation of their disability. 4, what actions the ARC must take if they determine that a behavior is a manifestation of the student's disability. And 5, what actions school officials may take if the conduct in question is determined not to be a manifestation of the student's disability. If the district, the parent, and relevant members of the IEP team make the determination that the conduct was a manifestation of the child's disability, the IEP team must either 1, conduct an FBA, unless the district had conducted an FBA before the behavior that results in the change of placement occurred, and implement a behavior intervention plan for the child. Or 2, if a behavior intervention plan already had been developed, review the behavior intervention plan and modify it as necessary to address the behavior. The IEP team also must return the child to the placement from which the child was removed, unless the parent and the district agree to a change of placement. In addition, when the removal is for weapons, drugs, or serious bodily injury under the regulations, the child may remain in IES as determined by the child's IEP team for the duration of the removal, but not more than 45 school days, regardless of whether the violation was a manifestation of their disability. If the behavior in question was the direct result of the district's failure to implement the IEP, the district must take immediate steps to remedy those deficiencies. When applying the key takeaways from this section, districts may want to review their manifestation determination review policies and procedures with school personnel to ensure clear understanding of the steps involved in the MDR process. That includes understanding what information may be needed in preparation of the MDR meetings, such as current behavior data, teacher observations, teacher collected data, and any relevant information provided by the parents or others with knowledge of the student. In being proactive, the district may want to discuss in advance what immediate steps they may take if the behavior in question was the direct result of the district's failure to implement the IEP.